All right, you can hand out the jury instructions, please. In a few minutes, I'll begin reading the instructions. As in the first page, you can read along with me. You'll have a copy back in the jury room when you look at it. Members of the jury, you have heard all the evidence and the argument of counsel. It is now your duty to make a decision as to the appropriate sentence that should be imposed upon the defendant for the crime of first-degree murder. There are two possible sentences: one, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts proven aggravating factors may be considered in support of a death sentence. The aggravating factors alleged by the state are: one, the defendant was previously convicted of another capital felony. The crime of first-degree murder is a capital felony. Previously convicted of another capital felony includes capital felony convictions resulting from crimes contained on separate victims during a single criminal episode. Two, the first-degree murder was committed for financial gain. Three, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. You have heard the evidence about the impact of these murders on the family, friends, and community of Voncile Smith, Richard T. Smith, John W. Smith. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Voncile Smith, Richard T. Smith, John W. Smith's deaths. However, you may not consider this evidence as an aggravating factor. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction is one which is not stable, or one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, the conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find the aggravating factor does exist. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You will be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility for parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors have been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty. And you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. If you do unanimously find the existence of at least one aggravating factor and that the aggravating factors are sufficient to impose a sentence of death, the next step in the process is for you to determine whether any mitigating circumstances exist. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. Among the mitigating circumstances you may consider are: one, the first-degree murder was committed. Did any juror need any water?
Yes.
Oh, can we get a bottle of water?
Yes, sir. Thank you.
That's fine. Among the mitigating circumstances you may consider are: one, the first-degree murder was committed while the defendant was under the influence of extreme mental or emotional disturbance. Two, the capacity of the defendant to appreciate the criminality of his conduct or to conform his conduct to the requirements of law was substantially impaired. Three, the defendant's age at the time of the crime. Four, the existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The juror's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factors are sufficient to impose death must be unanimous. Your finding that the aggravating factors found to exist outweigh the established mitigating circumstances must be unanimous. And your decision to impose a sentence of death must be unanimous. You will be provided a form to reflect your findings and decision regarding the appropriate sentence. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. When considering aggravating factors and mitigating circumstances, it is up to you to decide which evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Did the witness's testimony agree with the other testimony and other evidence in the case? Had the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on a subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses. Is this paragraph applicable? Okay, that next paragraph you can just disregard at this stage. All right. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called in the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant exercises a fundamental right by choosing not to be a witness in this case. He must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. There are some general rules that will apply to your discussion during your deliberation. You must follow these rules in order to make a lawful decision. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, your decision must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits in evidence, and these instructions. 3, your decisions must not be based upon the fact that you feel sorry for anyone or angry at anyone. 4, remember that lawyers are not on trial. Your feelings about them should not influence your decisions. 5, your decisions should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. In just a few moments, you'll be taken to the jury room by the court deputy. When you have reached decisions in conformity with these instructions, the appropriate form should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. You are not to communicate with any person outside the jury about this case, You must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the court deputy. During this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that made you think I preferred one decision over another. If you need to communicate with me, send a note through the court deputy signed by the foreperson. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. In closing, let me remind you that it is important that you follow the laws spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and law. No juror has the right to violate rules we all do. All right, any objections to the instructions of this?
Not to say. No.
Okay. All right, members of the jury. You had a preview several days ago. I told you in every case we have alternate jurors. And the service of the alternate jurors are, as you hopefully understand by now, just as important as the jurors who will deliberate. As you've been previously told, the alternate jurors are needed for deliberation in case one of the other jurors becomes ill or otherwise can't continue. And let me tell you, that does happen with a good degree of regularity. So the alternate juror service was just as important and necessary for the conclusion of this case as any other juror. And again, in this case, the alternate jurors are Ms. Barden and Ms. Spann and Mr. Jones. All right, again, with our great thanks and appreciation of the sacrifice you've given for over 3 weeks, you'll be excused at this time. At this point, you are free to discuss your participation in this case, although you're not required to. That's completely up to you. And thank you again. You're hereby excused. Hope you have a nice weekend. Please be seated. And just a few moments, the jury will be released to begin your deliberations. Once we get the all clear that the alternates have left the jury room. And you will have the instructions, you will have the verdict form, and you will have all the exhibits when you go back. Also, do we have the electronic evidence? Is that being sent back also from the...
I think it passed the court judge, I'm not sure.
Well, the first phase of evidence will go back also? Okay, so if there's anything you want to play, you're unable to play it, send a note to the court deputy letting us know. And just give you the word when they're clear.
Got one in the restroom.
Okay. Pardon? All clear? All right, you may now retire to begin your deliberations. All right, please be seated. All right, I intend to let the jury deliberate as long this evening as they wish to go. Did anyone want to discuss any contingency plans?
No.
All right, very good. Anything else to discuss before we recess?
Not from the state.
All right, just make sure your contact numbers are with the deputies. All right, we'll be in recess till we hear from the jury.
All right.